Hello everyone, welcome to another episode of Coach Today by Live Law, your one-step destination for the latest and fastest legal updates. I am your host Urvashi Chauhan, bringing you day-to-day happenings, landmark judgments, crucial rulings and expert insights into the world of law. Let us start. We start with the headlines and a brief overview of the top stories, and then we will dive into full details and in-depth coverage of each update. The Supreme Court has today stayed the NGT order restraining number of members in Dhol-Tasha-Zanj Troupes for Ganpati Visarjan in Pune. The top court has observed that representation against preventive detention must be decided soon because each day's delay in cases of personal liberty matter. The Supreme Court has stayed an FIR against a mother for allegedly making false accusation of the father sexually abusing their 3-year-old child. The Supreme Court has imposed 1 lakh cost on a man for repeated litigations to change birth date in service records. A court in Uttar Pradesh has convicted 16 persons in an alleged illegal mass religious conversion case and sentenced them to life imprisonment. A PIL has been filed in the Allahabad High Court seeking CBI probe into leader of opposition Rahul Gandhi's citizenship. The Jharkhand High Court has upheld charges of disclosure of rape victim identity via WhatsApp groups against Jamtara MLA. The Allahabad High Court has dismissed a PIL for inclusion of Taekwondo, Judo, Karate as regular courses for girls in classes 1st to 8th. The Supreme Court has today stayed a direction issued by National Green Tribunal that had limited the total number of Dhol-Tasha-Zanj members in each troop during the Ganpati Visarjan procession in Pune to 30. The tribunal had also directed for real-time monitoring of noise pollution around each Ganesh Pandal and initiating criminal proceedings against the violators. An appeal was filed against the NGT direction before the top court, and an urgent mentioning was made by the appellant this morning, saying that the matter required early hearing since the Visarjan is scheduled to happen on 17th September, which is next week. Advocate Amit Pai, representing the appellant, said that Ganesh festival has a deep cultural significance for Pune. He added that the appellants were not aggrieved by the other directions issued by NGT for controlling noise pollution during the Ganesh Chaturthi celebrations, but the one restricting the number of Dhol-Tasha-Zanj members. The bench led by CJI D.Y. Chandrachud, comprising Justices J.B. Pardiwala and Manoj Mishra, issued notice and stayed the NGT direction. The Supreme Court has today quashed preventive detention of a person on account of delay of 9 months by jail authorities in communicating the representation of the detainee and also non-supply of relevant materials. Let me tell you, the detainee here was detained in August 2023 under Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974 by the detaining authority to prevent him from allegedly indulging in hawala dealings, illegal purchase, sale and carriage of foreign currencies, etc. In the grounds of arrest given to him, he was informed of his right to representation to the detaining authority, State Advisory Board of High Court of Kerala and the central government via jail authorities. Accordingly, he made representations to all authorities in September. But the jail authorities sent the representations further through ordinary posts which could not be traced. The wife of the detainee had to file a habeas corpus petition appealing against the detention orders, which was dismissed by the Kerala High Court in March this year. The wife filed a criminal appeal before the Supreme Court then, which issued notices and sought jail records. After this, jail authorities transmitted representations via email, which came to be rejected by the central government and the detaining authority in June this year. The court found that even the subsequent representations, there was a delay of 27 days. The court found that even in the subsequent representations, there was a delay of 27 days and 20 days respectively on the part of the central government and the detaining authority in deciding the representation. noting that on both accounts there was a delay of 9 months and 27 days for subsequent representations. The bench of Justices B.R. Gawai, Prashant Kumar Mishra and K.V. Vishwanathan quashed all detention orders and set aside the judgment of the Kerala High Court. The court has ordered the release of the detainee from detention. Also, calling out the jail authorities for casually dealing with the fundamental right of the petitioner, the court said that representation against preventive detention must be decided soon. In the next update, the top court has stayed the order of the Kerala High Court, which led to lodging of an FIR against a mother for allegedly making a false case against the father of the child under the POCSO Act. The Supreme Court stayed the observations made by the High Court against the mother and stayed the proceedings in the FIR. To give you a brief background, the mother here had alleged that the father had sexually assaulted their 3-year-old child. But the Kerala High Court observed that it was a frivolous complaint with an ulterior motive to get custody of the child. The court noted that in her statement before the court, the 3-year-old child had deposed against the mother. So the court said that the prosecution against the father of the victim was to be quashed. The court had further observed that in cases where a father has been accused of sexual abuse, especially during custody disputes, the facts must be thoroughly reviewed by the courts. It said that such cases must be handled with great seriousness because if the allegations are true, they are grave, but if false, they can unjustly ruin a man's reputation in society. Post these observations, an FIR was lodged against the wife under Section 22 of the POCSO Act, which deals with punishment for false complaints. So against the same, the wife now approached the top court. The bench of Justices B.V. Nagratna and N. Koteshwar Singh issued notice in the SLP and stayed the observations made by the High Court as well as the proceedings in the FIR against the wife. The Supreme Court bench of Justices J.K. Maheshwari and Rajesh Bindal has imposed a cost of 1 lakh on an engineer who initiated multiple cases before different forums seeking change in date of birth recorded in his service records. The petitioner in this case, an engineer, had his date of birth recorded as 10th April 1962 in his service records. In the year 1999, he realized that there was an error and that it should have been 23rd April 1964. He filed a civil suit in 2007 to correct this in his school and service records, but it was dismissed. He then appealed to the district judge and later the High Court of Himachal Pradesh, but both rejected his claim. Then in 2012, he took the matter to the Supreme Court through a special leave petition, which was also dismissed. His review petition met the same fate. Later, through an RTI, he got to know that his birth record had been corrected to the new date of 23rd April 1964 by the Registrar of Death and Births. So with this, he filed another petition in the High Court asking for his date of birth to be corrected in his records also. But the High Court refused, pointing out that the case had already been decided by previous courts. This was in the year 2022, and the High Court even questioned as to how the new birth certificate was issued, ordering an inquiry into the matter. The inquiry revealed that the new birth certificate was in fact invalid. Despite all this, the petitioner kept challenging the decisions, including filing the present SLP in the Supreme Court. After going through the material, the Supreme Court bench observed that the date of birth was sought to be changed by the petitioner after nearly 35 years, having spent more than 10 years in service. The court, expressing disappointment, noted that the petitioner had pursued his claim through 8 rounds of litigation despite it being against the established legal principles. The court emphasized that his repeated attempts were in clear violation of settled law. Dismissing the plea, the court directed that the petitioner deposit a cost of 1 lakh with AIMS Poor Patients Fund within a period of 3 months. A special NIA court in Uttar Pradesh's Lucknow district has convicted 16 persons in an alleged illegal mass religious conversion case and has sentenced them to life imprisonment. Additional District and Sessions Judge Lucknow, Vivek Nand Sharan Tripathi, sentenced Maulana Umar Gautam, Mohammad Kaleem Siddiqui, and 10 others to life imprisonment for their convictions under IPC and the Uttar Pradesh Prohibition of Unlawful Conversion of Religion Act. 4 others were sentenced to 10 years of rigorous imprisonment. They had been charged with running a mass religious conversion racket through several organizations and schools which they funded, and by receiving funding from international organizations. The convict Siddiqui was arrested by the Anti-Terrorist Squad of Uttar Pradesh Police in September 2021. Besides forcible conversions, he had also been charged of promoting enmity between different religious groups and disturbing India's sovereignty and integrity. The case of the prosecution against Umar Gautam was that he used psychological pressure for forceful conversions as part of their plan to set up an Islamic State and received funding from different countries to carry out conversions. It was a charge of the prosecution that their object and goal were to change the demography of the country by converting the citizens from one religion to another religion and to disturb the peace and tranquility of society. In another update, a PIL plea has been moved before the Allahabad High Court to direct CBI to register a case under provisions of the Bharatiya Nyaya Sanhita against Congress leader and leader of opposition in Lok Sabha, Rahul Gandhi, and conduct a detailed investigation into his alleged British citizenship. The PIL plea also seeks to set aside Gandhi's election as an MP from the Raebareli Lok Sabha seat on the ground that he is not an Indian citizen but a British citizen and therefore ineligible to contest the Lok Sabha polls. The petition has been moved by BJP Karnataka member S. Vignesh, who had moved another petition which was 2 months ago dismissed as withdrawn by the High Court. In this new PIL, the petitioner Vignesh claims that after his previous plea was dismissed, he contacted the Ministry of Home Affairs, but they have not responded yet. He also did more research, found new information, and contacted the UK government about Rahul Gandhi's citizenship records. Vignesh learned that in 2022, another person named VSS Sarma had already asked the UK government for the same details. Sarma shared confidential emails with Vignesh which allegedly show that UK government has records of Gandhi's British citizenship. However, the UK government stated that they cannot release this information without Gandhi's permission due to data protection laws. Thus, the PIL now seeks a detailed CBI investigation. The Jharkhand High Court has declined to quash charges against Jamtara MLA and Minister for State's Rural Development, Dr. Irfan Ansari, who has been accused of circulating the identity of a minor rape victim to the media via WhatsApp. The case stems from a 2018 incident when Ansari, along with his supporters, visited a minor rape victim admitted to a hospital. It was alleged that during the visit, the victim's name, address, and photograph were taken and later shared with media outlets and other organizations on WhatsApp groups. The court further noted statements of a witness which revealed that a photograph of the teenage girl along with a message had been posted in the WhatsApp group from Ansari's phone. The content of the message indicated that the teenage girl was a victim of rape and that her name was disclosed in the post. Though Ansari claimed that the message was posted by his secretary, the court observed that prima facie involvement of Ansari in disclosing the identity, including photographs of the victim over social media, was established. A single bench of Justice Arun Kumar Rai referred to Section 228A of IPC, which prohibits printing or publishing the name or rape victim identity in any matter. It further held that Section 23 of POCSO Act, which bars revealing the identity of minor rape victim in any form of media or studio or photographic facilities, includes WhatsApp groups. And lastly, the Allahabad High Court has dismissed a public interest litigation seeking inclusion of Taekwondo, Judo, Karate course as regular courses for girls in classes 1st to 8th. The petitioner had approached the High Court claiming that introduction of the aforesaid as regular courses would help the girls in becoming independent, self-confident, and help them in facing all difficulties that they may encounter in their life. The court observed that the petitioner had written a letter to the Chief Minister on 2nd May 2024 and filed the petition within 15 days. Observing that the petition was filed without any research and with general averments, the bench comprising Chief Justice Arun Bhansali and Justice Vikas Budhwar dismissed the PIL. If you wish to know more details about the cases that I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.